The disputes arose between PASL, which was a company registered in Ahmedabad, and GE Power, which was registered in Chennai, of course part of the GE group. The disputes arose out of purchase orders entered into between the parties, and subsequent to that, the parties entered into a settlement agreement. The settlement agreement had the dispute resolution clause in question. The dispute resolution clause said that disputes between them would be settled by arbitration seated in Zurich. It was in this context that PASL commenced arbitration. GE took the objection at that stage that two Indian parties could not have chosen a foreign seat of arbitration. The arbitral tribunal rejected that argument and held that the seat of arbitration was in fact Zurich and that Mumbai was only the venue for arbitration. Subsequently, the award in the arbitration was passed, the claims raised by PASL were rejected, and it was with this background that GE then approached the Gujarat High Court to seek enforcement of that award and also filed an interim application to seek security against the amounts awarded. PASL, of course, opposed enforcement of the award and surprisingly took the stand, which ran contrary to the stand that they took in arbitration, that two Indian parties could not actually have picked a foreign seat of arbitration. The Gujarat High Court rejected that argument. However, on the question of interim protection, it said that an interim protection in such an arbitration was not maintainable. It was in this background that the matter came up before the Supreme Court. Primarily to pick and answer two questions. One, whether two Indian parties could choose a foreign seat of arbitration, and two, whether in such arbitrations interim reliefs could be awarded. The Supreme Court held that having argued that two Indian parties could in fact agree on a foreign seat of arbitration, and having agreed before the arbitrator that the seat was in fact Zurich, and having opposed Mumbai as the venue of the hearings, PASL could not now take a stand which was contrary to that and argue that two Indian parties cannot in fact choose a foreign seat at arbitration, merely because the award was against them. The Supreme Court once again gave primacy to the party autonomy concept and the freedom to contract. They also added that by choosing a foreign seat of arbitration, the two Indian parties are in that sense getting two bites at a cherry. That is to say, first the recourse to the court or tribunal in a country outside India for seeking setting aside of the arbitral award, as per of course the laws of that country, and secondly to resist enforcement under the grounds available in the Arbitration Act. The Supreme Court said that there was no clear and undeniable harm being caused by permitting two Indian parties to choose a foreign seat of arbitration, especially given that the foreign award, as I said, would anyway have to pass muster under the procedures of the country, and also given that its enforcement can be resisted in India on the grounds contained in the Arbitration Act, which of course includes grounds such as the award being contrary to the public policy of India. Therefore, it was in this background and on the basis of this reasoning that Supreme Court held that two Indian parties can choose a foreign seat of arbitration. Similarly, having already held that two Indian parties can choose a foreign seat of arbitration, the Supreme Court permitted that, in view of the same reasoning, interim reliefs were also available to parties to such an arbitration. This judgment assumes significance primarily because of the judicial recognition of party autonomy and for the Supreme Court having held that now Indian parties are free to choose a foreign seat. Having said that, Indian parties would still need to understand and accept that the enforcement of the foreign award will subsequently be challenged under the Indian Arbitration Act. So one must bear that in mind. Secondly, this concept may not always be useful to all Indian contracting parties because of the challenges to cost, logistics and timelines that are associated with the foreign seat. So that must also be borne in mind while deciding whether or not to choose a foreign seat. But of course, this will be an attractive proposition, especially in cases where the contracting parties are Indian subsidiaries of foreign companies, or in fact, even if one of the contracting parties is an Indian subsidiary of a foreign company, they might in fact prefer a foreign seat of arbitration. However, the clarity that this judgment brings is welcome and an important.